Hi everyone, it's James from Community Legal Centres Queensland here. Welcome to another one of our CPD webinars for people working in community legal centres. This one looking at recovering unpaid wages and entitlements. Before I hand over to Michael, our presenter, can I acknowledge the traditional owners of the lands on which we're gathered electronically. Michael's presenting from Townsville, I'm here in Brisbane, and we've got people tuning in from across the state, so we acknowledge the traditional owners of all of those lands and pay our respects to elders, ancestors and emerging leaders, and to any Aboriginal or Torres Strait Islander people who are joining us today. Can I just check that people can hear me? If you've played this game before, you can press the button that looks like a hand on your control panel. Terrific, there's some hands going up, so I'll take it that the sound is generally working well. Thanks everyone. Just a couple of housekeeping things for those who haven't joined one of these webinars before. A copy of Michael's PowerPoint presentation is available on the handouts section of your control panel. It's also available on our website, and I'll put a link in the chat box in just a minute if you can't access it through the control panel. And we hope to record this and make it available to everyone through the website, and I'll email some links through to that after the presentation. If you'd like to ask Michael a question as the presentation's going, there's a couple of ways that you can do that. You can type a question into the questions box on your control panel. We'll see that. I'll butt in and interrupt Michael and read or paraphrase your question, and he can respond to it. The other way that you can ask a question is to press that button that looks like a hand on your control panel. We'll see something that looks like a hand going up beside your name here. We'll be able to unmute your microphone. You'll be able to ask a question directly. If you can, please hold those questions over until the end of the presentation, because it can be a bit tricky given the limitations of the technology to make kind of address questions as we go. So hold them over, but if you do have an urgent question, please do raise your hand, press the button that looks like a hand, type a question into the questions box. That's my boring opening stuff. On to much more exciting things. Michael Murray is a solicitor with the Townsville Community Legal Service and will be presenting today on jurisdictional issues that we should be thinking about in unpaid entitlement matters. We'll flag that most of the content that Michael is talking about is looking at some of the different jurisdictions in Queensland. So if there's anyone on the webinar or watching this video later who's from outside Queensland, please do bear in mind that some of the jurisdictions we're talking about are state tribunals or other forums. But with my work done, I'll welcome and thank Michael for his presentation today and hand over.
Thanks, James. Thank you everyone for taking the time to attend this webinar today, organised by James and CLCQ and the Townsville Community Legal Service. Before I start, I too would like to acknowledge the Australian Aboriginal and Torres Strait Islander people as the first inhabitants of this country, and pay my respects to the traditional owners of the land on which we stand on today across Queensland. So as James said, my name is Michael. I'm a general civil lawyer at the Townsville Community Legal Service, and I was asked by James to present a webinar covering the topic of unpaid entitlements and some issues to consider when advising clients, particularly in a CLC environment, on means of taking legal action to recover unpaid entitlements. I think this topic is particularly relevant with the current employment and business climate in Queensland. In Townsville, we've certainly seen a huge increase in clients seeking legal advice for employment-related matters, particularly unfair dismissal and unpaid wages matters, and I think that reflects the climate of employment and business at the moment. Now, the area of unpaid entitlements is quite broad, and I don't have time today to cover everything in detail. So as James said, today I'm going to be focusing on some jurisdictional issues to consider and different venues that individual clients can take action in to recover unpaid wages and other unpaid entitlements. I'm also going to look at some practical considerations to you for the webinar, which you can see up on the slide. So just to start with, I'm going to be running an unpaid entitlement matter or seeing a client regarding that type of matter. So I'm going to be looking at briefly when someone is an employee, how that's different to other types of workers and what impact that may have on entitlements that are owed to them. And I'm also going to look at the different types of employees, such as full-time, part-time, or casual employees, and I'm going to look at how that's going to impact on entitlements. And I'm also going to look at where you might find an employee's entitlements if you're not sure what they are owed or what they may have been entitled to. After these basic considerations, basic but important considerations, I'm going to start looking at recovering unpaid entitlements through court or tribunal means in a bit more detail. And I'm going to go through some common jurisdictional issues that I've certainly encountered in practice up here and that you may have or certainly will in the future. So I'm going to look at state system and national system employees, so the difference between the two and how that impacts on the jurisdiction of unpaid entitlement matters. And then moving the focus over to national system employees, I'm going to look at in a bit of detail the changes to recovery of unpaid entitlements that Fair Work brought in and what mechanisms for recovery of unpaid entitlements are available under the Fair Work Act. I'm also going to look at QCAT's jurisdiction for unpaid wages and unpaid entitlement matters in Queensland. QCAT is certainly a preferred jurisdiction for most self-represented litigants, but it has become increasingly apparent in the past few years that national system employees, so those employees covered by the Fair Work Act, their unpaid entitlement claims may fall outside the scope of QCAT's minor civil dispute jurisdiction. So I'm going to look at how the Fair Work Act has impacted on that. And then to finish off, I'm going to run through some further considerations, both jurisdictional and practical, for lawyers or advocates and CLCs to consider when advising clients in relation to these types of matters. So things like the practicality of the venue, the complexity, the cost of filing in the venue, the risk of potential cost orders, or rights to legal representation, and small claims as well. And then we'll have some time for questions at the end, but like James said, if you've got a question, feel free to interrupt and I will try and answer it as best I can. Now, you see on the slide there, paper forthcoming. Our service is writing a paper on the jurisdictional issues that covers all of these issues in detail and quite a bit more. It's almost finished and hopefully it will be in the near future, so I'm happy to circulate that through James to anyone that wants it, or if you contact me directly, my email's on the first slide, I'm happy to send it through to you also. So to start with, I'm going to run through the basic, I've called them basic considerations, but they really are very important considerations. I suppose the basic is just referring to the fact that they're one of the first things I consider when advising a client in unpaid entitlement matters. So is the client an employee? What type of employee are they? And where their entitlements may be found. These are important because they're going to help build a picture of who your client is and what they're entitled to and what may not have been paid to them that they were lawfully entitled to under the Fair Work Act or another instrument. So the first question you may be faced with when seeing a client regarding an unpaid wages or entitlement matter is what was the relationship between the client and the employer. This is important because there are lots of different ways that a person can perform work. They could be an employee, a volunteer or a contractor, for instance, and they'll all have different entitlements depending on their status. So just by way of an example, if a person is an independent contractor, they generally don't have the same entitlements as an employee. So independent contractors generally aren't entitled to a minimum rate of pay or conditions such as annual leave, parental leave, sick and carers leave, long service leave, or redundancy payments. So their entitlements are going to be mainly contractual and not found under the Fair Work Act or an award or an EBA. And likewise for a volunteer who, unlike an employee, may have no entitlements. So just to cover this section briefly regarding whether or not someone's an employee and to determine if an employment relationship exists, there's no single factor to assist that or single factor that distinguishes an employee from other types of employment. And generally each case should be looked at carefully and individually if there's any doubt. There is a common law test for determining whether or not an employment relationship exists or one of a different kind, such as a contractor. And you can see they're up on the slide. This basically involves identifying and weighing up various features of the relationship to determine what it actually was. And a range of features that I've listed there on the slide, I've just pulled them straight from the Fair Work website, and I've got the link there to that table as well. So as you can see on that slide, you're looking at features of the relationship such as superannuation, taxation, hours of work, work tools, expectation of ongoing work. All of these factors will assist clarifying the nature of the relationship, which will then in turn assist clarifying what entitlements may be owed. So it is important, first of all, to clarify that the client is an employee in the first place. Now, once it's clear that the person's an employee, it's important to then turn your mind to what type of employee they are. You may ask why, but this again is because it's going to impact on the types of entitlements that are owed to the employee or entitlements that they are actually entitled to on that or another instrument. So there's generally three types of employees. There's full-time employees who are normally contracted to work 38 hours per week, and the types of entitlements these employees may receive include paid leave, guaranteed hours of work, minimum notice requirements, and may be entitled to redundancies. There's also part-time employees who generally work less than 38 hours per week with semi-regular hours, but still an expectation that employment will continue. Part-time employees also receive paid leave, guaranteed regular hours of work, and have minimum notice requirements and redundancy entitlements. And the last category is casual employees who are hired to work irregularly. There's generally no expectation of ongoing work or fixed hours. They generally don't get paid leave, regular hours, and don't have minimum notice requirements or many of the entitlements that a full-time or part-time employee would get. So it is important also what your client is, because this is going to clarify what entitlements they're owed. Because if it's a casual employee, for example, they're not going to receive the same entitlements as a full-time or part-time employee. So once you've worked out that your client's an employee and the type of employee they are, you can then start turning your mind to what entitlements they're owed or what they're entitled to. This is important because a lot of the time, as I'm sure you're all aware, the employee has no idea what they're actually entitled to or where those entitlements are derived from. So there are lots of rules about what employees get at work, such as what hours they work, what leave they get, and these rules are set out in different places, which you can see I've listed there on the slide. So there are minimum employment entitlements for both state and federal employees. National system employees' minimum entitlements are set out in the National Employment Standards and Awards. The National Employment Standards, or the NES, are 10 minimum employment standards, excuse me, providing for entitlements such as pay and leave. A state employee's minimum entitlements, which are similar, are set out in the Queensland Employment Standards and State Awards. So in addition to these minimum employment standards, there are other sources where an employee's entitlements can be found. However, they can't be less than what's in the minimum employment standards or awards. So some sources to consider would be, well, first of all, I've got awards there. So an award is an instrument which sets out the minimum standards of employment for a particular industry. They usually set out minimum rates of pay, entitlements, and conditions for each industry. They cover most industries, but not all industries, such as professional workers. So a large amount of people, like lawyers or accountants, aren't going to be covered by awards. A contract of employment is another source. So an employee's terms and conditions of work might be outlined in their letter of offer or a contract, or set out in oral conversations. Now, these matters will form part of a contract or agreement, which will impact on the entitlements that the employee is owed. Some employees may also have enterprise bargaining agreements, or EBAs, and these apply to all employees of a particular employer. These conditions can be different to an award, but they are subject to the Better Off Overall test, which is a fair work test to ensure that employees are better off overall. Most enterprise agreements provide for higher wages with more flexible work hours, as well as adjustments of penalties or rates. So where to find these documents? Well, if your client's under a contract and they don't have the contract, you can obviously approach the employer for a copy of the contract if it's written. Alternatively, for things like the National Employment Standards or awards or EBAs, all of this information can be obtained from the Fair Work website. So you can search for full copies of awards and EBAs. If you still have any doubt what award might be applicable to your client, you can contact the Fair Work directly by telephone, and they're generally fairly helpful in pointing you in the right direction or providing you with the correct award. So that's the last basic consideration. It's important to know what entitlements your client has so that you can assist them in working out what's owed. So you can see I've got there, once you've worked out your client's an employee, they might be covered by an award, or you know what entitlements they're owed. What do you do next? Well, this is when you can begin to look at what legal avenues they might have available to recover these entitlements, and that's when some important jurisdictional considerations are going to come into play, and you have to start thinking about what venue it might be appropriate for your client to take action in, because there are a few and they may not all suit your client, or your client may not have jurisdiction to file in certain venues also. Now, from a jurisdictional standpoint, the first question I find that you're going to be faced with when considering an unpaid entitlement matter is whether or not the person falls under the state or national industrial relations system, or in other words, whether or not that person is a state or a national system employee. And I'm going to be covering both of them in this webinar. So firstly, let's look at state system employees. So what's a state system employee? Well, in January 2010, when the Fair Work Act came into operation, the state government referred industrial relations coverage of all employees in the private sector to the national system. So this means that all employees in the private sector will have no remedy for unpaid entitlements through the Queensland Industrial Relations Commission, or the QIRC. So who are those employees that would be captured by the Queensland Industrial Relations Commission? Well, these are state or local government employees mostly, so people that might work for the Queensland government, public servants, or people that work for the local council. They all fall under the state system. So they can make claims for unpaid entitlements to the Queensland Industrial Relations Commission. So in the Act, in the Queensland Industrial Relations Act, it's section 278, which sets out the civil remedies for unpaid entitlement matters, and sets out that the QIRC can order a state system employer to pay a state system employee unpaid entitlements. So just a few points to note with the QIRC. I'll just run through it quickly. So it has a monetary limit of $50,000. Proceedings or claims must be lodged within 6 years of the loss occurring. Representation is generally not permitted for matters under section 278, so those are matters for unpaid entitlements. The Commission does facilitate conference settlements to help encourage settlement prior to having to have the matter set down for a trial. Costs can be ordered only where applications are vexatious or made without reasonable cause, so it's a limited cost jurisdiction for these types of claims. And decisions can be appealed. Sorry, you have to excuse me, I'm just getting over a flu. Sorry. Decisions can be appealed to the full bench or the Industrial Relations Court within 21 days, so there is an avenue of appeal as well. So you can see on that slide, I'm only covering the state system briefly. Most of this presentation focuses on national system employees, but that slide just sets out the general process for filing a claim in the QIRC under Section 278, and all of this information is available on the QIRC website. So that's state system employees. What about national system employees? So as I said before, generally all private sector employees will be covered by the National Industrial Relations System. So this system was established in 2009 under the Fair Work Act, and it also established the Fair Work Commission and the Fair Work Ombudsman. So under that system, a national system employee is defined as an employee who is employed by a national system employer. So this includes people employed by private enterprise or constitutional corporations or the Commonwealth. So generally anyone that's not a state employee will come under the national system. So the Fair Work Act does provide for methods of recovery of entitlements for national system employees. So I'm going to run through that now and run through the legislative scheme. So Part 4 is the section, it was the part in the Fair Work Act that sets out the civil remedies for unpaid entitlement matters, and these are for national system employees only. So look, while I'm not covering it in detail today, well, first of all, Section 541 provides that a Fair Work Inspector may apply for orders in relation to safety net contractual entitlements. Excuse me. And that can be very useful and successful in some instances, as I mentioned before, with the 7-Eleven employees who just got quite a big judgment, and the employer got quite a large pecuniary judgment against them also. So Section 542, subsection 1 provides that for the purposes of Part 4, a safety net contractual entitlement of a national system employee has the effect of an entitlement of the employee under the Fair Work Act. Okay, so then Section 12 then goes on to define what a safety net contractual entitlement is. So it means an entitlement under a contract between an employer and an employee that relates to any of the subject matter described in the National Employment Standards, or anything that may be subject to a modern award. So this is looking at things like wages, overtime, leave, penalty rates, redundancy. So you can see from Section 542 and Section 12, the Fair Work Act has set a very broad definition of what safety net entitlements are. So it's really most things a private sector employee would receive, such as wages and leave and things like that. So the definition itself is very broad. So Section 543 of the Act then provides for means of enforcement of entitlements. So this is getting into the actual mechanisms that employees can use. So a national system employee, it says there, may apply to the Federal Court or the Federal Circuit Court within 6 years to enforce an entitlement. And that's any of those entitlements falling under that broad definition in Section 12. Section 545 then goes on to set out the orders that can be made by particular courts. So the Federal and Federal Circuit Court can make orders that unpaid entitlements be paid by a national system employer, and they can also make pecuniary orders. What's referred to in the Fair Work Act, as I've bolded and underlined it there, an eligible state or territory court can also order an employee to pay an amount, order an employer to pay an amount to an employee if the employer was required to pay that amount under the Fair Work Act. Now, in addition to all these mechanisms, I will just point out that Section 26 of the Fair Work Act states that these remedies are intended to apply to the exclusion of state or territory industrial relation laws, insofar as they apply to a national system employee. However, some state and territory industrial laws are not excluded by the operation of Section 26, including claims for enforcement of contracts of employment, and that's set out in Section 27. So that's the mechanisms under the Fair Work Act for recovery of unpaid wages. Application to the Federal or Federal Circuit Court, or an application to an eligible state or territory court. So I guess this begs the question, does QCAT have jurisdiction to hear unpaid entitlement claims for national system employees? Well, this really depends on two questions, as you can see on the slide. So the first question is that I'm going to run through is QCAT an eligible state or territory court? And the second question is QCAT capable of dealing with claims of enforcement of contracts of employment within the meaning of the exception to Section 26 of the Fair Work Act? So that's the exception there you can see at the bottom under Section 27. So these questions have been looked at in detail in two decisions of the QCAT and the Appeals Division, which I would suggest reading to get your head around. I'll run through them now also, but especially the decision of Ford, very useful to read. So I'm going to look at Urban first. The matter of Urban involved an application by a gentleman who was, from memory, a real estate agent in QCAT, and he was seeking to recover unpaid annual leave entitlements under a national award. So clearly an entitlement under the meaning of Section 12 of the Fair Work Act. Now the decision makers in Urban took a strict approach to the Fair Work Act's jurisdiction. So they basically found that the Fair Work Act actually goes to the trouble of defining an eligible state or territory court. And you can see there on the slide it includes a district, county or local court, a magistrates court, the Industrial Relations Court of South Australia, or any other court prescribed by the regulations, which is none. And therefore they found that because the Fair Work Act actually went to the trouble to make an exhaustive list, that QCAT had no jurisdiction because it wasn't included in that list. So Mr. Urban's appeal was thrown out, and it was found that QCAT had no jurisdiction to hear his claim. Now moving on to Ford. Ford took a less strict approach to Urban in certain aspects. So the matter of Ford involved, excuse me, a lawyer actually seeking to recover unpaid entitlements from his former employer. So these entitlements included things such as notice pay, annual leave and superannuation. Like Urban, the decision makers in Ford found that the Fair Work Act entitlements, that for Fair Work Act entitlements, the Fair Work Act provided exclusive mechanisms. And QCAT wasn't listed as a court in those mechanisms, and therefore it wouldn't have jurisdiction for Fair Work Act entitlements. Now, however, the decision makers in Ford went on to find that the Fair Work Act had not completely stripped QCAT's jurisdiction to hear employment claims, noting that entitlements not covered by the Fair Work Act. So that could be entitlements arising under a contract of employment that may exceed statutory entitlements or are not provided under the Fair Work Act, may be enforced in QCAT's minor civil dispute jurisdiction, provided, of course, it met other requirements of QCAT, such as being a debt or liquidated demand. So Ford found that the Fair Work Act had certainly limited QCAT's jurisdiction, but the jurisdiction wasn't completely excluded by Section 26 or the civil remedy provisions of the Fair Work Act. Excuse me. So after Urban and Ford, where does this leave QCAT? Does it have jurisdiction? Well, it's clear that the Fair Work Act has impacted on QCAT's jurisdiction. So with its introduction, it brought new mechanisms for national system employees to recover unpaid statutory entitlements. And these that we just went through are found in Part 4 of the Fair Work Act. And they provide that for those entitlements for national system employees, you can commence proceedings in the Federal Court or the Federal Circuit Court. Now, however, this was in addition to the right to pursue damages for breaches of contract of employment in an eligible state or territory court, which, as we discussed earlier, doesn't include QCAT, but does include Queensland Magistrates Court according to Section 12 of the Fair Work Act. So QCAT may have jurisdiction to enforce unpaid entitlements where they're clearly not a Fair Work Act entitlement, and if it meets other requirements such as being a debt or liquidated demand. However, considering the broad definition of entitlements under the Fair Work Act, which we went through that definition before, so entitlements under a contract between an employee and an employer that relate to any of the subject matter described by the National Employment Standards or maybe the subject of a modern award, so topics like wages, overtime or leave. In my view, there's likely limited matters that would be captured by QCAT's jurisdiction for national system employees. So if not QCAT, then where? Well, under the Fair Work Act for Fair Work entitlements for national system employees, your client's claim could potentially go to the Federal Court or the Federal Circuit Court or an eligible state or territory court, which includes the Magistrates Court of Queensland. So as you can see from the slide, both federal and state courts have a small claims procedure. So under the Fair Work Act, the Federal Circuit Court and the Magistrates Court of Queensland have jurisdiction to hear small claims for employment matters. And a small claim is a claim of up to $20,000 for unpaid entitlements. Generally, the small claims process is quicker, cheaper, and more informal than regular court proceedings, with limited costs, as in administrative costs, and also a limited risk of cost orders. However, it also has a limited right to legal representation, which we'll discuss later. Excuse me. So for claims greater than $20,000 for national system employees, for national or safety net contractual entitlements, I'll call them, which is probably uncommon for a CLC claims that high, then you'd have to look at taking general court action outside the small claims procedure in a court of competent jurisdiction under the Fair Work Act. So that could potentially be the Federal Court, the Federal Circuit Court, or the Queensland Magistrates Court, considering those mechanisms we went through earlier. And obviously, because it's outside the small claims procedure, there's going to be a whole different range of issues to consider, such as formality and costs and cost orders and things like that. So those are the mechanisms for recovering unpaid entitlements, but there's also some other, I suppose, considerations that you should certainly be thinking about when giving advice to your clients in these areas. Some of these are practical issues, and I'm going to finish off the webinar today just by running through these issues that assist your client in, well, assist you in guiding your client in the right direction and the right venue. So firstly, in relation to venue, I just wanted to put the question out there, what's going to be available locally for your client? I say that because, for example, in Townsville there's a Federal Circuit Court here. That's great, but it only accepts filings for family law or child support matters. So other civil matters such as claims outside the small claims process or fair work claims through the small claims process in the Federal Circuit Court have to be filed through the Brisbane Registry. So that's something to consider, because for us, dealing with a registry some 15 hours away, is that going to be possible for the client, or would they be better off considering filing an employment claim in the small claims division in the Magistrates Court in Townsville? Another issue to consider is the monetary jurisdiction. So that's an obvious consideration. Probably most centres wouldn't see claims often more than $20,000 on a regular basis. I just wanted to point out that, as I've said before, the Federal Circuit Court and the Magistrates Court actually have a simplified claims procedure for claims less than $20,000. So in most circumstances, if your client's a self-rep litigant, it's probably beneficial for them to be in a small claims jurisdiction as opposed to anything else. Alternatively, they may have to consider, if their claim's more than $20,000, they may have to consider not going through small claims and filing a general claim, which complicates the process profoundly, especially for self-represented litigants. And this brings me on to my next point, which is complexity. So it's important to consider the complexity of litigation in each venue. So obviously QCAT may have the most procedure and hearing process and limited rules of evidence and things like that. However, as we've spoken about, QCAT may not have jurisdiction and likely doesn't have jurisdiction for most matters. So luckily both the small claims process in the Federal Circuit Court and the Magistrates Court have simplified procedures. And these are set out in the Federal Circuit Court rules and the Magistrates Court of Queensland Act, which you can have a look at there. So for the Federal Circuit Court for small claims, judges aren't bound by any rules of evidence. They may correct mistakes in applications. They can act informal, and neither party can be represented by a lawyer unless permission is granted, and it's only granted in limited circumstances. So employment claims in the Magistrates Court, the process is also different and simplified from your standard civil claim and statement of claim under the UCPR. So certain rules under the UCPR are actually excluded to this process. So rules regarding pleadings, for instance, don't apply to employment claims for the small claims under the Magistrates Court. There's also compulsory conciliation with an approved conciliator to encourage settlement, and there is a limitation on awarding costs and also a limit on legal representation during the conciliation process. And the next one also, so also just consider filing and service fees and any other administrative costs that may be incurred by your client should they proceed to litigation in one of the venues that we have been speaking about. So most venues have reduced filing fees for employment or small claims matters. However, if you're filing outside the small claims procedure, make sure you factor these filing fees into your advice, especially in the Federal Court and Federal Circuit Court. The fees are quite substantial. And also just keep in mind that other costs might be incurred down the track, such as, for example, personal service by a bailiff or ASIC searches and things like that. So I find it's always important to reality check the client on costs and help them make a commercial decision moving forward on whether or not their claim is worth proceeding. And of course, legal representation is also an important consideration. So does your client require legal representation? And you can see there I've also put, or is it perhaps strategic to deny the other side legal representation, which in some circumstances can be good. Now, if you can get a claim in QCAT under that limited jurisdiction, as I'm sure you're aware, representation is generally not permitted unless given leave. So it's generally not permitted unless there are complex questions of fact and law, and it is permitted for children or people with an impaired capacity also. Now, in the Magistrates Court for employment hearings, it's generally permitted but subject to other conditions. So you're unable to be legally represented, an employee is unable to be legally represented during a conciliation. And in the Federal Circuit Court for small claims, it's not permitted without leave of the court. And then you can see there at the bottom of that slide, representation is also generally permitted outside small claims processes in most jurisdictions. So I've got there cost orders as well are another important consideration. So you also need to give consideration to cost orders and which venues carry the risk or the opportunity of a cost order should you need it. So generally in QCAT there's a limited power to award costs. Each party normally bears their own costs. Costs can be awarded where there's unfair conduct and things like that. Now in the Federal Circuit Court Small Claims Division for Fair Work matters, costs will only be awarded like the Magistrates Court employment claim where proceedings are commenced vexatiously or without reasonable cause. That's under Section 570 of the Fair Work Act. And you can see there under Section 42 of the Magistrates Court Act, the Magistrates Court also has a limited power to award costs for employment claims. And I haven't got it there, but obviously outside small claims procedure, there generally is the power to award costs in most jurisdictions, so be aware of that. It's always important to advise clients on risk of costs orders. And I've just got on that slide some useful contacts and referrals. So if you're referring clients, the QPIL has a self-representative service in the Federal Circuit Court and Federal Court in Brisbane. Have a self-rep service in Townsville, but I'm not sure if that extends to the Federal Court. Caxton Legal Centre has a dedicated employment law service which has started up recently, and Working Women Queensland can give advice and assistance to women in these types of matters. And also other generalist service such as TCLS might do them. If you're looking for referrals, you can probably contact CLCQ to find out. Okay, that's the end of everything I wanted to cover today. So have we got any questions?
Nothing coming through yet, Michael. Can I thank you for the presentation on behalf of all of our participants? Guys, folks, I should say, there are a couple of ways that you can ask questions. I'll remind you, you can type a question into the questions box on your control panel, or you can put up that button that looks like a hand on your control panel, and we will unmute your microphone and get you to ask a question. The one that jumps out to me, Michael, was around choosing jurisdiction and the factors that you could consider in deciding to take the litigation path as opposed to going through the Fair Work Ombudsman.
Yep.
Why would you bother going to court? What's the advantage over the Fair Work Ombudsman's process?
As I understand it, the Fair Work Ombudsman won't do all matters. To be honest, I get most of my referrals for unpaid wages matters from the Fair Work Ombudsman, so they're obviously not going to run every matter for every client. They do run some big matters and some big public interest matters, like the 7-Eleven one recently. But certainly I didn't cover it in here because I just wanted to focus on the jurisdictional issues, but that's certainly another avenue if you're seeing a client that's been underpaid or isn't sure about their entitlements. It's often a good first stop to contact Fair Work Ombudsman to see if they can assist.
So if a client's walking into your centre and saying, I've got unpaid wages, would your approach ordinarily be, have you been to Fair Work? And if not, go there and come back and see us if they can't help.
Well, generally, the first thing I ask is, have you been to Fair Work? 90% of the time they say yes, and they've given me your number. So they've been referred to us. If they haven't been there, we generally give them advice in the matter and tell them to contact Fair Work to see if they can assist, but if they won't, then to come back and see us.
Terrific. A reminder, folks, you can ask questions by typing them into the questions box or pressing the button that looks like a hand on your control panel. Michael, a question that's coming in asks, if the client is seeking only payment for commissions, would you pursue that through QCAT? So not wages per se, but commissions.
Well, I might just see if I can answer that now, but it might be something I need to look at. It's not something I've come across for, commissions. What type of employment are they in?
That's an excellent question. Can I ask this questioner, Sue? I might try and unmute your microphone. Sue, do you have a microphone there? Are you able to speak?
Maybe not.
So I guess the question is whether this falls under the Fair Work Act's jurisdiction or just general small claims jurisdiction that QCAT would have, Michael.
Yeah, I'm not too sure. You probably need to look at look at the Fair Work Act and look at the definition of safety net contractual entitlements and look at what modern awards cover and what the minimum entitlements cover. If that covered commission, if that could cover commissions, then potentially it would fall under Fair Work jurisdiction, so Federal Circuit Court. If it was not something that could be covered by the Fair Work Act, then I think it would fall under state jurisdiction. I'm happy to look into that a bit more, Sue, if you want to contact me after the webinar. I just can't find the section that I want to look at right now.
Sure. Sue's clarified that a bit. The client was worked with tour groups and was to be paid commissions in addition to the wages in that context.
Okay. Were they covered by an award or anything like that? Or
no, might be a bit particular, so I might by email put you and Sue in touch, and we might come back to the group with.
Yeah, I'm certainly happy to follow that up.
Terrific.
So I just can't find the section now.
Thank you. This is a pretty useful question. If an employee wins a wages claim, are they guaranteed to see all the money that they are owed? So I guess it goes to questions of enforcement of orders at QCAT or in these other jurisdictions, Michael.
Yeah, I mean, no is the simple answer. I mean, that's part of giving the client the commercial reality check. So if someone's gone bust and you're suing them for unpaid entitlements, then obviously, despite even if you get a judgment, they may never have the capacity to pay, so you're never going to get that back. There are other schemes such as the Federal Entitlements Guarantee or Scheme, I think it's called. The name has just escaped me. But where companies have gone bust, you can apply under that scheme to have entitlements or a portion of entitlements paid by the government. And an example of that was in Townsville recently, Queensland Nickel. Clive Palmer's nickel venture went bust in Townsville. Employees were left millions and millions of dollars owing in unpaid entitlements, and they've recovered most of them through the Federal Entitlement Scheme. I think it's called.
Terrific. I might give a gratuitous plug, Michael, for one of our webinars coming up in September. We've got someone from Ashurst presenting on what we're calling Debt Collection 101, which will include enforcement of court and tribunal debts amongst other kinds of debt enforcement.
So once it comes to enforcement, it's sort of a completely different area, I guess,
sure.
Because there's a whole bunch of other considerations that are going to come into play.
Another quite interesting question. If the employer has entered into external administration, can legal proceedings be commenced?
Check the Bankruptcy Act, I guess. Yeah. I'm not too sure off the top of my head.
We might take that on notice as well, Jess, and come back to the group with the response to that question. So, Michael, that's the questions we've got so far. I might just give people another minute or two. Actually, I'm not even going to give them a minute or two. The next few seconds, if you've got a question, punch it into the questions box or press that button that looks like a hand on your control panel.
And if Sue and Jess, if you want to just flick me an email, I'm happy to follow those issues up.
Terrific, thank you. Michael, I think given that it's 10 to 5 on a state of origin afternoon, that might have just about worn people out. Can I, on behalf of all of the people who participated in the webinar, thank Michael for a detailed and thoughtful presentation. We've had someone chip in with a suggestion that rather than the Bankruptcy Act, the External Administration Corporations Act might be the legislation just to look at around that. Again, we might take that conversation offline. Michael, thanks for that presentation. As I said, we'll forward, even better, Section 670. Mark, you are a champion.
There you go.
Thanks, Michael. Thanks, everyone. We'll email around a copy of the PowerPoint presentation and hopefully a link to the recording if that technology works. Thank you all, and we'll speak to you soon.
No problem. Thanks very much.